We're excited to invite here Illia Roskoshnyi, who's going to be speaking on human-state interaction in the Information Society International Agenda and Ukrainian Subtext. Dr. Roskoshnyi is one of two visiting scholars with us from the Ukraine for the year. He has a PhD from Karazin Kharkiv National University, with his dissertation being on constitutional and legal principles of human-state interaction in the Information Society. His areas of research are constitutional, municipal, transportation, consumer information, international, and comparative law. And we're very excited to hear his talk today. In the invite for today's lecture, there's also a link to publications that Illia has written, so be sure to check those out. And we'll hand it over to you. Thank you.
Thank you very much. Thank you very much for my introduction to the audience. I'm very appreciate you that you come here. Thank you for your coming. And today we are going to talk about human-state interaction in the Information Society, International Agenda, and Ukrainian Subtext. The beginning of the lecture focuses on the background foundation of the Information Society, followed by an exploration of the theoretical side of the Information Society, and finally the practical application of the Information Society across state. So we start from the background foundation of the Information Society. We all love to chat, and so did our ancestors who made the first information revolution. The first information revolution was oral. This happened with the invention of language as a means of communication. Why this revolution called oral? Because knowledge and information are transferred orally way. This made their life, our ancestors, easier and provided prospects for development, but after some time they noticed that with the death of a person, all knowledge and all progress go away. They thought about a new types of communication. With this thought, they moved to the second information revolution. With the invention of writing skills, the second information revolution took place. The writing was a natural way out of the situation in the framework of the first information revolution. The writing skills helped to improve the acquisition, storage, and transmission of the usage and customs in the society. But it was difficult to write on stones and rocks. There is only one stone and rock with information, but there are many peoples that want to read it. It is difficult to transport a stone, and it can collapse, and all knowledge will be lost. People needed something new, more portable. Papyrus and handwriting were a good way out of the situation, but did not have such strong impact as printing press typography. So the third information revolution took place with the invention of printing press and typography. You can see this in the slides. This method of spreading knowledge was one of the best at that time, and a great option to spread information at a lower cost. Education was becoming cheaper and more accessible. The various points of view disseminated by printed information have accelerated the evolution of man. But this was not enough to start even. And in the middle of the 19th century took place the fourth information revolution. The first information revolution was approximately from the 19th to the middle of 20th century. This revolution reflected to the world change provoked by industrial revolution. This was due to the invention of electricity, the telegraph, telephone, TV, and radio. Exactly these devices what provoked this industrial and information revolution. And I would like that you compare this first invention of first TV, telegraph, telephone, radio with our today devices. And I can say even more, we have one devices which help us to substitute all this technology. It's our smartphones. And I would like that you remember this slide. In the end of the lecture, I will remind this slide. Exactly this listed devices and electricity increase the spread of information at times, improving education, human rights protection, and general well-being. A natural extension of this revolution was the invention of the possibility of a faster exchange of information. The computer and internet become such devices. The fifth information revolution was exactly connected with the invention of the computer and further the internet. The use of these new approaches to data processing has facilitated the spread of information at times and lowered its cost over the time. Exactly this stage of information revolution is connected with the appearance of the information society. The consequences of these 5 information revolution we can watch today, and after some time scholars will identify some new stage of the information revolution. And we can compare the first computer which was invented and now our small laptops. Someone emphasized that the fixed information revolution brought together a network of computers. But I think that the network of computers is mature level of the information revolution. Digitalization of society or society of knowledge, one of the next of the fixed information revolution. What about society of knowledge? I can say that we see a huge amount of information on the net, conflicting news, any misleadings, manipulation of public opinions, attempts to abuse the trust of society. And this must be overcome by an ordinary person. And the success of this person depends on his knowledge and skills to determine what is a true and what is a lie among a huge amount of information. By the way, the psychological state also depends on the correct understanding of the information. Digitalization of society will come to us with the digitalization of any services, government services and government at all, as well as business digitalization. Appearance of artificial intelligence will increase this, but we don't have now the authentic artificial intelligence. We don't know what will be the next, and by the time we will see what will be. So we get acquainted with the first, a brief historical background of human-state interaction in the information society. And now I would like to briefly to introduce you to the theoretical and philosophical part of the information society. Philosophical part of the information society related with the names of Claude Shannon, Herbert Wiener, Alan Turing, Yuhayashi, Yuneji Masuda, Herbert Marshall McLuhan. All these philosophers called the new transformation of society the information society. But in the fact, more scientists were interested in and developed the theory of the information society. But they called it differently. This contributed as well to the creation of a new type of society. At that time, they also associated the information society with knowledge, but in those conditions, the knowledge was rather a means to achieve the goal, I mean the developed information society, than as a means of overcoming existing problem of the information society, which would lead to a new formation of society, knowledge society or digitalization society. One of the first mention I would like to go to the one of the first mention of the information society, and I would like to count all the most famous manifestation of the information society, which were called differently. It's called post-capital society, post-market society, post-enterprising society, post-bourgeois society, post-conventional society, post-traditional society, industrial society, active society, programmable society. And I would like to explain about one of the first formal mention of the information society. One of the first mention of the information society was in Japanese. And Japanese began use the concept of the information society at the state level. The title of the government act says it all. Japanese Society Plan, 1971. The contour of the assistant informatization policy in Japanese society. Japanese information society themes and approaches. Now we turn to the philosophical part of the information society. And I would like explain about thoughts and determination of the information society by Daniel Bell. He explained the information society a new title of the post-industrial society that not highlighting its place in gradual stages society development, post-industrial society, but its main social structure is information. George Willard Martin, US scientist, thought that from the economic point of view, information already become fundamental significant, and that with confidence possible forecast that until the end of this century, he means 20th century, in developed states will be established information economy and thus information society. And we can see this how it is in our society work. John Naisbitt, US futurologist, said that the transition to the information society is one of the main trends of transformation in the West and then throughout the world. Since in the society 70s entered into an economy that was based on information, the development of complex technology is the biggest test for a person. There is a transition from the national economy to the global one, from short-term planning to long-term planning, from centralization to decentralization. Next, I would like to explain about thoughts of Alvin Toffler, US philosopher, the author of the bestseller The Third Wave, noted about human evolution. He said that the first wave, agriculture, in which the land was the basis of the economy, life and politics. The second wave, industrial, the basis of the functioning of which were labor and capital. The third wave, information, based on application of knowledge. The third wave brings with it a new way of life on various renewable energy sources and method of production, which make most factories warehouses or conveyors. The third wave is the historical barrier between the consumer and producer, which generate the economy of tomorrow, which is called prosumer. The word prosumer is constituted from the word producer and consumer. And I would like to highlight that he said this in 1980s, and we see how it is in our life. Alvin Toffler highlights three types of authority. The first, low quality authority based on force transferred into brute force and violence. Medium quality based on wealth, and high quality based on knowledge. Then I would like to explain about the concept of the information society by Herbert Marshall McLuhan. A Canadian scientist, a graduate of our university, University of Manitoba, has also taken part in the world discussion about the information society and become famous as the prophet of electronic communication from Toronto. Herbert Marshall McLuhan claimed that under the pressure of electronic means of communication, the world turns from a global village into a global theater where everyone performed the role assigned to him by the structure of audiovisual TV culture. he said that means of communication media, not only media is it commonly believed. These are electricity, oral speech, writing, roads, numbers, clothes, accommodation, city, money, clocks, printing, phones, books, playing games, etc. All these tools are technologies or intermediaries, the introduction or implementation of which makes significant changes in the communication of person with the surrounding world, both natural and social, and reorganize his way of world perception and way of life. At the end of the theoretical and philosophical dimension of the information society, I would like give you a good example about the information society. About 85 years ago, 30 pages of the text sent to distance 5,000 kilometers more cost take 10 days and cost about $30. About 45 years ago, the same 30 page of text sent distance 5,000 kilometers cost take 1 hour and cost about $50. Now the 30 page of the text sent distance over than 5,000 kilometers cost almost free. From this slide we can understand how our life and our information society changing from that understanding to understanding of today. Actually, in world history there are a huge number of different thoughts that deserve attention, but because of the short format of this lecture, I think that it's worth moving directly to the practice. Practical, I have divided the international acts that related to the information society into international for whole world and international for a certain region, union, and states. I called it international standard and interstate standard of the information society. To the whole standard can be attributed to the United Nations documentation, declaration, and proclamation. There are so many declarations and conventions that we can describe in this lecture, but I would like to emphasize some of them as an example. You can see from the slide, this is the Aarhus Convention, the Millennium Development Goal, the Geneva Declaration of Principles and Plan of Action, etc. The interstate standard of the information society attributed to the next legal act, for example, Okinawa Charter Okinawa Charter on Global Information Society, Deauville Declaration, or other documentation. It's very difficult to explain about all of them. In my dissertation, I have analyzed each of them and even more in detail, but due to the frameworks of this lecture, I think worth moving on further, namely to the experience of the foreign states and the Ukraine experience. As we know from the jurisprudence, legal theory, and philosophy of law, and the theory of John Locke and Thomas Hobbes, state authority are separated into branches to ensure observation of the principal check and balances into legislative, executive, and judicial. And in the information society, the interaction between a person and the state will be in the three directions. The interaction between the individual and the legislative is commonly referred like e-democracy, e-election, or e-petition. The interaction between a person and judiciary is usually called it like e-court and e-participation. The interaction between a person and the executive is commonly called e-government. But this is e-election, e-participation, and e-petition just like some branches of for example, e-election and petition are branches of e-democracy, and we have more names and more interaction in e-democracy, e-government, and e-court in the word experience, which we can't explain for one lecture. But this is the general understanding of this e-democracy, e-government, and e-court. So we will go to e-democracy and e-election. The concept of democracy means the interaction of person in the state in the field of representative or direct democracy. The concept of e-election and e-petition are competence of the concept e-democracy. Since these tools, people can influence representative bodies. But in the broader sense, e-democracy includes any means of communication with the legislature. Such communication can be carried out through any letters, email, petition, proposal, motions, etc. to the legislative authorities. In addition, the forwarding can be in any form, electronic or regular one, at the choice of sender. This type of communication helps to correct the shortcomings of the legislature and improve their work. If we analyze the experience of foreign states, I can say that the prerequisite of such interaction as rule are currently laid down in the constitution of states. For example, I would like to show the US Constitution in the First Amendment, famous as Bill of Rights, defined that Congress shall make no law respecting the right to the people peaceably to assemble and to petition to government for a redress of grievances. The French Declaration of the Right of Man, 1789, is an integral part of current French constitution and also provide for some kind of the background of human-state interaction in section 15 and 14. 15 you can see in the slide, but I would like to emphasize section 15. 14 you can see in the slide, but I would like to emphasize section 15. Society has the right to require of every public agent an account of his administration. As well, sections 69.1 and 72.1 current French constitution also provide the possibility for interaction with the state body via petition. 69.1 defines that a referral may be made to the Economic, Social and Environmental Council by petition in the manner determined by an institutional act. After consideration of the petition, it shall inform the government and parliament of the pursuant action it process. 72.1 defines that the defender rights shall ensure the due respect of rights and freedoms by state administration, territorial communities, public legal entities. Referral may be made to defender of rights in manner determined by an institutional act, by every person who considers his right to have been infringed. He may, as well, the defender of rights may act without any referrals. Ukrainian constitution also provides the right to interact with the state and include that everyone has the right to file individual or collective writing petition or personally appeal to bodies of state's power, bodies of local self-government, and to the officials and officers of these bodies that are obligated to consider this petition and to provide substantiated reply within the term established by law. Section 16 of Japanese constitution also provides for the right to interact with the state and includes that every person shall have the right to peaceful petition for the redress of damage, for the removal of public officials, for the enactment, repeal or amendment of laws, ordinance or regulation, and for other matters. Nor shall any person be in any way discriminated against for sponsoring such a petition. Sponsoring means supporting and filing this petition in Japanese understanding. As well, I would like to emphasize the Constitution of Romania, Article 51, which defines that the exercise of this right to petition is exempt from tax. As well, it's in almost all country petition, you can file petition for free. So many examples show us that right to human-state interaction is international recognized human rights. So if we will back to e-democracy, e-petition and e-election, it means that all these petition, motion and grievances should be sent not only with the regular paper one version, but also with the help of modern technology such as email, special petition program, special program for referendum, special program on recall a deputy representative of society, and etc. Why etc.? Because there are so many states in the world and with their individual system for interaction between a person and the legislature, and they have the unique system of interaction with their peoples. A petition. So what we can to do with modern email technology for e-petition? We can send individual or collective written appeals, proposal, and petition to the legislative authorities, the legislative authority of the region, as well as officials and officers of these bodies. Of course, these documents that we will send must be correctly drafted, but the main in these things, the right to send documents to authorities by email, the form special program, which is now common in some states or becoming a trend. I would like to explain about advantages of this e-election and e-petition. This way of interaction provides so many advantages, such as you save money on sending, on transportation, on your time. You don't need to go to a government office, state office, or postal office. Especially, it's this is a way of interaction is relevant for part of the world with very hot or very cold temperature. Just imagine winter or summer, you're sitting in your cozy house or apartment and you need to go to a post office to send a letter. It's not good imagination, especially if the road is dangerous in winter time. Emails or special program will help overcome it. We will save, of course, money on consumption of paper, and also this way of interaction helps people with physical disabilities who will not need to overcome any obstacles to reach the final destination of the post office or government office. And as well, it's saved on money. I would like show you experience and good example of Estonia. Estonia was one of the first in the world who used e-voting tools in 2005, which was then used by only 1.87% of voters, and in the 2019 there was almost 50% of them. And from this example we can understand that people need time to understand all advantages or disadvantages of some technology. But we can understand that every action has its drawbacks. Unfortunately, I don't have time to explain this. Perhaps it could be the topic of my next lecture. And now we will turn to the e-governments. The concept of e-government is closely related to public services. This means that we can receive all public services using modern technology that is online. I would like to say in a few words that one of the main ideas of e-services was to limit the power of bureau state officials, since the officials could no longer find a fault with documents or wording because the program did it for them. Those legal sections from Constitution that I explained about e-democracy also apply to the means of communication with government, because human right guaranteed to file any petition to any state bodies, including executive branch. Thus, it is clear that we can send a petition to executive branch in the same way, but bulk of e-governments is government services, which regulated by other law. So, what do public services through e-government tools mean? This means that we can receive almost all government services online or remotely. Such public services can be vehicle registration, marriage registration, obtaining patents and license, notary services, business registration, tax services, real estate registration. Indeed, the number of public services huge and can describe for each specific situation or specific conditions. Of course, some public services or all at once can be transferred to the online space, but over time we will overcome this. For example, if earlier we couldn't even imagine that it's possible to issue a notarized power of attorney or get married via Skype, open business in couple clicks, or apply for a state pension through special website, now it is reality of today. As for benefits, here is the same benefits as in the topic of e-democracy, plus we must understand that we will save human resource officers because the digitalization of public services will reduce the number of workers and space required for meeting. This action will save money for public funds. Now we move on to the word e-government experience. I would like to explain about US. In 2002, the United States passed the Electronic Government Act, which accelerated the implementation of government technology in the human-state interaction. In particular, the act brought to the people of United States improved interaction with the judiciary, Section 2205, the executive branch, and the protection of personal data. In 2010, United States passed the Cybersecurity Act, which helped overcome existing concerns about human-state interaction and ensure security with this interaction. France. In France, since 1978, January 1978, National Commission for IT Liberties has been operating. This commission works to improve an understanding of possibilities of modern technology for people and propose amendments to the current legislative system to improve this interaction. Code on the relationship between the public and the administration provides for France to interact electronically with the government and legislature. The code also obliges the administration to inform citizens about the possibility of electronic communication with the state. China. From 1998 to 2015, domain names gov.cn in China increased from 145 to 58,000. This was due to the government policy and the existence of the government online project since 1999 and the work of China Telecom Company. All this website provides public services and public information. According to China's National Statistical Commission, in 2015, 100 of government agencies were online. In 2017, in China adopted the Cybersecurity Act, which had to ensure security on the web. There are two basic applications for which using as a digital tools for human-state interaction, WeChat and Alipay. These two applications are analog WhatsApp and Viber. Via these two apps, people of China can get access to public services as well. And in light of COVID-19, this trend was increased. Now I would like to explain about Ukrainian experience and Ukrainian development of human-state interaction, which connected with the European integration. In Ukraine was adopted so many acts for ensure this integration and according to the directive of European Union. And you can see all of them in the slides. There have been so many amendments to the civil, criminal and administrative codes to improve human-court interaction. I would like to explain about one of them. The Act on the Petition of Citizens provides that anyone can send any petition or motion to any authorities or individuals. Individuals means to any company and business as well, both by email in paper form. The authorities also provide for filing a petition via telephone. In Ukraine, an oral form of petition also practiced through special program EasyCon or in person. You can make petition in person to any state officials. Electronic petition, you can see the main screen of the web of electronic petition, is relatively new tools in Ukraine. This way of filing a petition assumes that someone will post a petition on the official website of petition, a petition to any state body, including the municipality. Then there is 30 days to vote, and if there are 25,000 votes, it's for the state level. And then it should be considered at the next plenary meeting of the body to which it was sent and give an official response within 10 working days. The DE application includes a lot of e-government and e-democracy features. Through this application, citizens can take part in survey, government survey, open a business, receive a pension, receive an allowance, apply for construction, obtain license, receive a COVID-19 vaccination certification, receive childbirth certificate, receive an extract or certificate from any public register, report on tax or transport issue. The application also provides a digital documents with QR code, which is equivalent to paper one. In the slide you can see this QR codes. Now in wartime, this type of interaction is especially relevant because of the non-functioning conventional service centers that war took away. So as we can see from the slide and practical part of the human-state interaction, the first is the introduction or implementation of new technology. And the second is security issue, because the government, for example, in the US, e-Government Act was adopted in 2002, and the Cybersecurity Act in 2010, and in many countries in the world, the same situation. But from a reasonable side, it is obvious to think about two questions at the same time, because in this case we will face such problem in the future. This is regularity. But frankly, these new technology are not cheap, because we constantly need to think about safety of these actions. We need to solve online or remote means of communication. We need to refine or update it, etc. But in general, this technology are not about money. This technology about the future, about a good future for the nation. And without such tools, it will be difficult to achieve. The topic of e-government is extensive, that every human interaction with the state in the field of family relation, transport relation, etc. needs at least such lecture to clarify and understand all subtleties. So we will move on to the e-court and e-participation. The e-court and e-participation tools have similar to those of e-government and e-democracy, as well as their unique tools one. So I would like to explain about the similar tools are relating to the administrative function of court. What does it mean? The court in its work is faced with several issues, the first of which are issues about prosecution, litigation, and other functions related to the administration of justice. All these interactions are regulated by a special procedural code, acts, rules, or the law. The second, these are issues about their administrative functions. This means that in this list we can include almost all functions that don't relate to the administration of justice. Such function can be information about the automatic distribution of cases, court agreements with municipal or other legal entities, payroll information, or payment information. To the second type of information, we can get access through tools the same as for petition and e-democracy and e-government. So we can move on to the unique tools for e-court. For this first issue, special programs were invented, such as special email boxes and special procedure for sending a letter and email. Why so? Because every civil, criminal, and administrative procedure has its limitation period and legal requirements to drafting. Special programs help keep track of deadlines and help draft suitable documents subject to the procedural requirements. And I would like to explain about advantages of e-court. You know that many use application, motion, and special documents for the court are approximately similar, and a special program has a huge number of templates for these documents, where you should only fill in the merit of issue, circumstances, and names. For example, some loans debts suits are naturally the same, and you need to replace names and circumstances. Beyond doubt, this action facilitates access to the court and justice in general. The second advantage of this is the ability to get acquainted with the case materials online and promptly object to certain motion or documents of the second party. The third advantage is that you can stay in any part of our beautiful earth and send any documents to court. You don't bound to the land of judicial jurisdiction. I mean the land literally. You have to follow rules of jurisdiction, but you don't need to be in the place where court is located. The fourth advantage is that you will save your time on sending to the court documents, paper, energy, time, as well postal court services. Maybe in one particular case this is not so much, but on the national scale we will see clear progress. The fifth advantage is that you can't lose the documents for court during transfer. Timely receipt of documents contributes a quick resolution of case. The service in court works day and night, and you don't need to adjust to the working hours of the courts or post. All documents keeps in the system, and you can review them around the clock, and you don't have worried about losing them. In fact, I can list for so long, but in general, the court tools make it very easy to access to the court, and these tools is the future of the judicature. As well, I would like to explain about another innovation in the electronic court is artificial intelligence in the field of decision making. This type of interaction began to discuss it in the 2000s, and some kind of implementation was as well in 2000 and 2010s. The main idea of such interaction was that artificial intelligence made all decisions instead of judges on small civil and administrative claims. The background of this innovation was taken from Amazon, Alibaba, and another online marketplace that received online claims against seller about breach of the rights of consumer and resolve it. The current vision of AI court is that AI will act as a lower court in minor civil and administrative disputes. The decision of the AI court can be applied to the can be appealed to the court of first instance with the participation of a live judge, or to the court of appeal instance. Indeed, this type of litigation are very useful for the current global judicial system, because many cases in the courts are actually easy and don't require so big human participation. For example, in Ukraine, divorces are resolved only in court if two parties don't have mutual agreement. In such cases are very easy if party don't have children or properties. Other examples are with loans, financing, and mortgages. These types of social relations are highly regulated, and the decisions are almost formulaic. Either consumer protection right, in most cases, is solved easily in this way. Anyway, if you don't agree with this decision, you can appeal it, but we should note that this saves a lot of time for parties and help to them to understand the real, not functional situation with the prospect of the case. Also, these tools help to judge in case of appeal, because the judge can see motivation of the decision, and it's help him understand the shortcoming of this decision and shortcoming of AI court. One of the example of the court of artificial intelligence, debatable artificial intelligence court in Singapore. Singapore electronic filing system, which was implemented in Singapore in 2000, paved the way for the world's first nationwide paperless litigation system. It revolutionized the conduct of civil litigations through its facilitates for electronic filing, electronic extracts, electronic services of documents, and the provision of electronic information services. Singapore video conferencing technology is used daily, and the benefits of reduced travel time and cost are tangible. Every morning, case involving accused person in the remand prison and heard by video link. As some scholars assert that AI in Singapore online check pleadings against legal requirements, but in my opinion, it's just some manifestation of automation. But there is no any AI in this situation. Despite the good example of this court, the main disadvantage of this situation is that it removed the ability to provide a paper version of the pleading to the court. Another example is Netherlands' approach to e-court is e-court. In 2009, the online arbitration institution e-court started in the Netherlands as a professional, cheaper and quicker alternative to state courts, and was received government support. While a court initially handled simple cases varying from debt collection to labor cases as well as small claims procedures up to maximum 100,000 euros since 2015. It has exclusively taken on debt collection cases. i.e. in the Netherlands makes decision on debt collection. But as well, I think it's very debatable because I think that there is just automation, no artificial intelligence. Now I would like to explain about Ukraine and about Ukraine approach to e-court. In Ukraine, the following online services operate for the implementation of e-court tools. Here you can see the website of each court in website of judicial power of Ukraine. This site provides the website of each court in Ukraine, where you can see information about the work time of court, the number of hearing cases, with the name of parties, the order to access public information, the stage of the hearing cases, the result of the hearing, etc. The main tools in Ukraine is e-court. You can see the web page of e-court. With its help, you can file a sue, motion, appeal against any stages of court session and any actions of party or judges, and use the patterns template of procedural documents. See all documents of the case if you are the party of the process. Send any documents around date. Empower the counsel or other person to be a representative in court hearing. The program EasyCon. Via this, you can communicate with the court during the hearing remotely, online. All you need to do is submit a motion for hearing case through the e-court and access to the court online. This type of communication is particularly relevant if courts are located in another region. You will save time and money, and particularly in the condition of COVID-19 or other infection, you will save your health. The Unified State Register system, the Unified State Register of Court Decision provides 24 access to all court decisions and allows you to use special search tools. The Unified Database of Legal Position of the Supreme Court of Ukraine provides opportunities similar to the previous system, but the search tools are more advanced. SMS informing about the stage of the process and the subpoena is provided by Ukrainian courts if you will file a motion before the court. Now I would like to explain about word practice, how it is in our world. The French Civil Code provides for the possibility of interacting with the court electronically, subject to the requirements of the current legislation. Estonian codes of civil procedure provide that the court exempts the party from providing the paper form of the document if they send in an electronic version, and you don't need to send there to another party. This will be done by the court instead of you. For this action, the court is not entitled to surcharge. In South Korea, tools of e-court started to develop in 2010 via enacted act on the use, etc., of electronic documents in civil litigation, etc. For 12 years, almost all courts in Korea were equipped with electronic gadgets for e-courts. General litigation in South Korea consists of 3 elements: e-filing, e-case management, and e-courtroom. Through e-filing, parties to litigate can file litigation documents and evidence in electronic document format, which was impossible in paper litigation. E-case management enables interest holder to the litigation to manage litigation information electronically. E-court refers to ways of using electronic equipment, including projector and screen, for trials and hearings. In Israel, the next generation court system is an advanced document management system that was introduced in January 2007 as a pilot project for online documents filing and case management. Video conferencing technology is available in civil litigation in Israel. In the United States, a filing system is now standard practice for US federal courts. Now I would like to explain about e-participation. This type of interaction is useful as well as the e-court tools. E-participation facilitates communication between the court and the parties and other participants of the court session via modern technology. The separation from the e-court was due to the fact that there are different technology for creating these two types of communication. But I think that in the future we will definitely see the combination of these two parts of communication into one. The process of e-participation happened through two forms. First, a special program for communication, and second, from the nearest court building. If it is more convenient for parties or it doesn't have, or party doesn't have the opportunity to use a special program. Verification as a participant of the process is prerequisites. As a rule, you have to file a motion for hearing online. The motion is required to the preparing equipment for the hearing. An electronic signature can greatly simplify the verification of the process. Also, in the end, I would like in a couple words explain about e-state, which will be our future. E-state means all means of communication which we count today, and even more, because it will be interaction between the concept of this concept unite all meanings of electronic communication among all entities and peoples in society. In addition to those we have listed today, we can add the human business interaction, human legal entities interaction, and human environment interaction, human interaction. As we can see, so many social relations are moving to the website, into cyberspace, and our communication interaction with the outside world has changed beyond recognition if we will compare with second, third, fourth information revolution. Ways of buying groceries and goods are largely going online. The internet is in almost every corner of our wonderful earth, and we can communicate with our closest almost every time, of course, when we want it. The dissemination of information has increased exponentially. Digitalization in business relations has become a necessity rather than optional function. Also, in this context, I would like to highlight the human right to petition to any legal entities, business, which is guaranteed in many states of the world. This right allows improving the activities of legal entities and business in case a breach of the rights of people or consumer, and encourage its elimination in a pre-trial order. I would like to draw your attention to the topic of cybersecurity, regulation of cyberspace, human rights, freedoms and obligations in cyberspace, birth of new rights, freedoms and liberties, including constitutional rights, freedoms and liberties in cyberspace. These are very important issues for resolving because the security is integral part for harmony development of digitalization. But this topic, I hope I will explain in some other my lecture. The state is our unavoidable future. It will come to us step by step due to the digitalization of social relationships. the foundation of this interaction, I think, will be the theory of smart city. And I would like to emphasize I would like to remind you that that fourth slide where I showed you first TV, first telegraph, first radio, first phone, and for us it will be like this smart city and that first technology. Our city, it's the same like that technology if we will compare with our future smart city. And smart city will be foundation of the electronic state, and all technology will step by step, bit by bit, bring us to the electronic state. And in the end, I would like to thank you for listening, and if you have any question, please ask me. Thank you very much.